Hello, my name is Steve Mullins, Certified Microbial Consultant, and welcome to my Health and Safety channel. And today's title of this video is Black Mold and Renters' Rights in California. I say California because that's what I'm familiar with and that's where I do my inspections. Now, though the rights that I'm going to be talking about are specific to California, every state has their own version of these, and so should be able to look up these rights for each state depending on where you live. Now, I do need to first make clear that I'm not a lawyer, nor am I a medical professional. But so any statements that are made about law and any potential medical conditions are a result of my experience in the industry and information I have received from other authoritative sources. Now, we're going to talk about some of these rights and how they relate to black mold and mold in general. Now, let's start off. First of all, you may know, as I've said in other videos, that mold will start to grow in 1 to 2 days once it gets a water source. Once that becomes present, and it will grow, whether it be inside the walls, under your floor, somewhere in your home. The reason is because these spores have been present since the time your house was built. Now, as far as black mold and the toxic black mold that people have been familiar with or have heard about, the law technically does not differentiate between that and mold in general. However, I will say this, that if you have a case where you have definite black mold you've been exposed to that is considered more hazardous than, say, other molds, that may help your case when you're trying to get compensation, but that's really for your lawyer to help you deal with, not something that I can specifically. However, you do need someone like me that can do the inspection, take the samples, do tests of various sorts that will build a case that you can take to court if that is your goal or need. Continuing on, you may have heard about Senate Bill 655 in California that was passed in 2015 and went into effect in 2016, that basically requires property owners to maintain the property free of dampness and mold. Because dampness leads to mold and other microbial or bacteria growth. Now, just to try to make a realistic point here, a lot of times as a renter, one or a person or you may be afraid to bring something to the attention of your landlord, especially if you may have brought things to their attention before, such as a leak or mold or the like, because you're afraid they may ask you to move. But one thing to be cognizant of and to feel comfort from is that the law protects you against that. Did you know that once you report an issue, whether it be a leak or mold or something similar to that, and that the owner is now made aware of that, they cannot require you to move for 180 days until that issue has been resolved, or meaning after it's been resolved, because it's viewed as a form of retaliation, which is against the law in California. And let's take also another point. The landlords may like to raise rent from time to time for various reasons, but there's one reason they can't raise the rent, such as if, say, they are required to do work to do repairs on the property that have to do with, let's say, leaks or mold. They can't raise the rent for a certain period of time, which is between 1 and 2 years, but I forget. It's in the Renters' Rights PDF that you can get. And they can't raise the rent to recoup money for money they spent to repair the property for reasons like that. Now, it is true some landlords will still ask you or tell you to move because they don't plan on doing anything to fix these issues, such as moisture that has been caused by leaks or mold that has been caused by leaks. And they may even attempt to intimidate you or bully you, which is against the law that I've been informed of by my legal counsel. Now, did you know that when you have a situation, say, such as leaks or mold where the landlord has to do repairs, and let's say it's in order for them to do the repairs properly and remediate the situation, meaning remove the mold and bacteria, in some cases you may have to be vacated from the property. In other words, live somewhere else temporarily while this is being done. But did you know that the landlord's obligation is to put you up somewhere on their dime while this is being done? That's state law. Now, it's not something they go around advertising, but that's what the law says. And then they can't ask you to leave. They can't evict you. The law protects you from that. These are things to know and be cognizant of. Now, there's conditions that will make the unit unhabitable per code. And I'll give you a couple of examples. One is, let's say you have a kitchen sink that is not working for whatever reason. Maybe the plumbing's not hooked up or it's clogged by something that's not your fault, whatever the case may be. That they cannot collect rent during that time and for the period of time that kitchen sink isn't working, because it makes the house or the home uninhabitable per code. And that's what the law basically says. Now, also, let's say if you have no working bathrooms in the property at the time, the same would also apply. And there's a lot of various conditions that make a home uninhabitable per code where the landlord can't collect rent while that's the case and until after that is fixed. Now, that also applies to things related to, say, moisture and mold. If there's a certain level of moisture in the home and there's mold that's been proven to be present, and you don't really necessarily always have to prove the mold is there. If the house is wet in certain areas at a certain level of moisture, that can also make the home uninhabitable per code. And once you, let's say, send them a report from a inspector like myself that says this is the case, then that sort of lets them know you have an official notice, hey, this needs to be fixed, and all along with the fact that they can't really collect rent from you until that's fixed. Now, there's different ways of handling that, but that's another topic which we'll talk about later. Now, did you know that you can withhold rent from the landlord until these issues that make the home uninhabitable per code? And sometimes they don't even have to be that serious until they fix the property. And you're allowed to do that. Now, you're also allowed to, let's say, make repairs to the home twice a year and deduct it from your rent as long as it doesn't go over the cost of the rent. Now, that usually comes with conditions, as Renters' Rights of California specifies. You have to give them due notice, and if they don't get to something after a period of time, you can basically hire somebody and get it done yourself, and simply deduct that from the rent with your paid receipt and such, attached to your rent check, if you will. Now, that's what the law allows. Now, of course, most people aren't going to go to the extent of going up to the amount of rent, which can be kind of hefty, because no one's going to want to put on $1,000 or $2,000 or more, depending on how much your rent is, to take care of something that the landlord is obligated to, and then deduct it from your rent. Not usually, but just let you know that it's there. Now, keep in mind that landlords are not always cognizant about all these laws and rights that I may be talking about and that are listed in the Renters' Rights of California. Simply because they may not have been a landlord that long, they may not have dealt with that many issues, and also means they may only have one or two properties they manage, but yet the ignorance of the law doesn't excuse them from having to obey it. And simply, if you are having an issue with your landlord, you basically let them know that you know the law. And there's, of course, a couple of different ways of letting them know that as well, especially if you want to try to do it amicably and maintain as good a relationship with them as possible. Now, let's say you have, or let me change that. I usually will tell my clients, excuse me, I have my bird visiting here. Her name is Pearl. That if you do have a moisture or mold issue, that is the responsibility of the landlord, and they pay me to come out and do an inspection for them. Because maybe they don't trust the landlord to do it, or whatever the case. Then I will tell them they can normally get a rent credit from the landlord because I now found something that the landlord needs to fix. Now, the landlord may not like that, but it's something that needs to be fixed. It's a health and safety issue. And even though you may not have given them notice that I was doing an inspection, which you don't necessarily have to do unless it's required in your lease, because some leases do require that, then you should still be able to get the rent credit since you now found something that they need to fix. And plus the fact that they can be potentially liable for your health at that point. Of course, you give them the report. They're now given official notice by a certified professional that things need to be done. Now, let's say they don't really want to do what the report says, or for whatever reason, as I may have mentioned in another video. Then you need another kind of assistance at this point, which I'm not qualified to give. It would fall in the legal arena. Now, I have a PDF that can help you with that. All you have to do is put your email in the link below the video, and I'll send it out to you ASAP. And other than that, that's all for this video. Thanks for tuning in. And look at the other videos that may be available that can answer your questions, and we will have more coming out that will help hopefully answer other questions for you. Thanks for tuning in. Also, do a like and subscribe if you want. That does motivate me to produce more videos.